Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to the Employee Survival Guide podcast, produced by employment attorney Mark Carey. Imagine this. You spend years at the absolute top of your field. I mean, you're working 14, sometimes 16-hour days straight through weekends.
Oh, and holidays, too, usually.
Right, exactly. You're managing hundreds of billions of dollars in federal programs for your firm. You are undeniably making the company millions.
Yeah, producing at the highest possible level.
And then exactly one day before your 5-year anniversary, which happens to be the specific day, a massive chunk of your wealth-building assets and retirement matches are set to vest. You are just unexpectedly forced out.
It's a scenario that sounds almost too calculated to be real.
It really does.
But, it happens way more often than people realize. The timing there is just a stark demonstration of ultimate corporate leverage.
Yeah, and that highly calculated timing is just one layer of the staggering lawsuit we are examining today. It's Owens v. PricewaterhouseCoopers LLC.
A huge case.
Oh, massive. We are unpacking what happens when a highly successful executive alleges this systemic, coordinated discrimination by her colleagues.
Right, and more importantly, how a relatively new federal law collides with local city laws,
Exactly. To answer one massive question, which is basically, does a massive corporation get to lock your dispute behind the closed doors of private arbitration? Or do you actually get to air your grievances in a public courtroom for the world to see?
Yeah, this lawsuit is essentially a masterclass in modern legal strategy.
Yeah.
I mean, it really exposes the absolute friction between corporate employment contracts and civil rights protections.
Absolutely.
We have to look at who actually qualifies for those protections, right? And how these institutions use really complex structural mechanisms to maintain control over where and how a dispute is fought.
But to really grasp how these legal gears grind together, I think you have to look at the human toll first.
Oh, for sure.
The plaintiff here is Nina Owens. She is a 55-year-old Asian-American woman, and she is just a heavyweight in her industry. I mean, FinTech magazine literally named her one of the top 100 women in FinTech.
Wow.
Yeah. And back in 2019, when she was 50, PwC recruited her specifically to build out a digital transformation practice focused on payments.
Because that area had been languishing for years.
Right, exactly. The complaint notes it was really struggling. They brought her in to fix it.
And by all accounts, she totally delivered on that mandate, and under immense pressure, too.
Oh, the pandemic.
Yeah. In March 2020, as the pandemic was causing absolute economic chaos, she was asked to step outside her usual market to lead the CARES Act Main Street Lending Program integration.
Which is huge.
Massive. We are talking about overseeing multiple firms and partner-led work streams for a $600 billion federal program.
That's just wild.
And she successfully brought the project's risk level down from high to moderate. I mean, she was producing at the absolute highest possible level.
Right. Which makes the end of her tenure so jarring. She is told she has to leave the firm on June 26, 2024.
And her anniversary was?
June 27, 2024. Literally the next day.
Unbelievable.
Hitting that specific 5-year mark would have meant full vesting of her wealth-building assets. That includes 40% of her 401k match.
Ouch.
Yeah. By forcing her out 24 hours before that milestone, the firm deliberately prevents her from claiming the financial rewards she had spent half a decade building.
The sheer precision of that one-day difference, it just highlights the immense control the firm's leadership held over her financial future and, her career timeline.
Right.
And that concept of, control is actually the crux of the very first major legal hurdle she faced in bringing this lawsuit. It all comes down to her job title.
Because Owens held the title of principal.
Exactly.
And at PwC, a principal is essentially a non-CPA partner. So when you or I hear the word partner or principal, we automatically think of an owner, right? Someone with a real stake in the business.
Right.
But Owens's lawsuit claims she was, in reality, just a regular employee. And that distinction is everything.
It is everything. Because civil rights laws and anti-discrimination protections generally apply to employees, not true legal partners or owners of a business.
Because if you're an owner, you can theoretically protect yourself.
Right. If you are a true legal owner, the assumption is that you have enough power and leverage to, not be subjugated to a boss in the traditional sense.
Got it.
So the judge has to figure out, was she an owner or was she an employee? And to do that, the court looks at New York common law, which uses a specific 4-factor test.
Okay, what are the factors?
They examine the selection and engagement of the person, the payment of salary, the power of dismissal, and, most importantly, the firm's right to control the person's conduct.
Okay, let's apply that test to Owens. Because on paper, her compensation was primarily in equity shares of the firm, which certainly sounds like ownership.
It sounds like ownership until you look at the mechanics.
How so?
Well, PwC leadership could arbitrarily grant or take away her shares each year based on their own discretion.
Wait, really?
Yeah, if someone else can unilaterally dictate the value of your equity, you don't really have the autonomy of an owner. You're entirely dependent on their approval for your compensation.
Wow. And I guess the same logic applies to her power of dismissal. The complaint notes she was brought in as a direct admit principal with a contingent offer.
Right. Being a direct admit principal essentially means she was brought in sideways from the outside rather than working her way up through the standard internal promotion track to partner.
I see.
Because of that and the contingent nature of the offer, she didn't have the standard contractual protections or voting rights that a full tenured partner would use to challenge a dismissal.
So they could just get rid of her.
Yeah, a small subcommittee of the board could just force her withdrawal without any broad consensus.
It's like being named the captain of a ship, right?
Okay, I like that.
You get the fancy hat, everyone calls you captain, you're standing on the bridge, but there's a whole board of directors back on shore who are actually steering the wheel remotely.
Yes.
They pick your crew for you, and they can cut your paycheck or kick you off the boat entirely whenever they feel like it. You don't have genuine control.
That lack of genuine control is precisely why the court viewed her as an employee. The title of principal is really just a facade if the underlying reality is total subjugation to a management hierarchy.
Which she definitely had.
Oh, yeah. The court found that she was supervised by several layers of management who could assign her to projects, remove her from clients, prevent her from traveling to firm events,
Wow.
and even block her sales deals from moving forward. Because of that heavy-handed control, she successfully established that she was an employee.
Which means she's entitled to the protections of the New York City human rights law.
Exactly.
And she desperately needed the protection of those civil rights laws because the allegations of what she endured over those 5 years are incredibly severe.
They really are.
Owens claims she faced a systemic pattern of sabotage, bias, and just a hostile work environment from multiple male colleagues. Her first manager, a guy named Jim Russell, allegedly made public, overtly ageist comments.
Yeah, it's pretty brazen.
In one meeting, when an outside company asked to interview Owens as an expert, Russell allegedly announced to the team that the company, and I quote, only asks people to serve as experts who are old.
Unbelievable.
He also allegedly told another partner outright that women should not be partners.
But the allegations go far beyond just inappropriate comments.
Right.
The complaint describes active structural career sabotage. Russell allegedly provided Owens with fewer than 5 business leads in 3 years, while actively funneling lucrative leads to younger white male directors.
Just completely freezing her out.
And he also allegedly took away leads that Owens had generated entirely on her own and reassigned them to others.
And that structural sabotage really crystallizes when you look at the allegations against another partner, Andrew Luca.
Oh, the revenue credits.
Yes. Owens claims he systematically siphoned off her revenue credits. For anyone not familiar with the high-stakes consulting world, revenue credit is your lifeblood.
It really is.
It dictates your performance rating, your internal power, and ultimately your pay. Owens alleges Luca would intercept change order contracts.
Which are basically expansions of an existing project, right?
Exactly. If I sell you $1 million software integration and halfway through you decide you also want us to train your staff for an extra $200,000, that's a change order.
Right.
It's the easiest, highest margin sale because the client is already hooked. Owens claimed she would do the work to generate these expansions, and Luca would swoop in, have younger men sign them as the engagement partner, and just take the credit.
And he allegedly executed this through highly opaque accounting mechanisms within the firm's internal systems.
Yeah, the complaint mentions him turning off the sweep of revenue or keeping it in a master code. So
Yeah.
How does that actually work in practice?
Well, think of it this way. Normally, when a project finishes a phase, the internal billing system automatically sweeps those billed hours in revenue into the specific partner's performance account.
Like an automated tally of your success.
Exactly. But if you manually turn off that automated sweep, the revenue just sits in a generic corporate bucket, a master code.
Oh, wow.
From there, Luca could allegedly direct the finance department to manually move the revenue Owens generated into his own personal accounting code.
That is wild.
She alleges that at one point, he took a combined 70% of the revenue from a project she had originally sold. If she had been properly credited, she claims she would have easily exceeded all her performance targets.
So Owens brings all of this, the revenue theft, the stolen leads, the forced withdrawal one day before vesting to federal court, alleging systemic race, gender, and age discrimination.
Right.
But before the judge can even look at the evidence, PwC drops a massive roadblock. They file a motion to compel arbitration.
Standard playbook.
Yeah. They argue that because Owens signed an employment contract containing a mandatory arbitration clause when she was hired, she waived her right to sue in court.
Right. The whole dispute, according to PwC, has to be diverted into a private arbitration room.
Which is standard operating procedure for almost every major corporation today, isn't it?
Oh, absolutely.
Yeah.
The Federal Arbitration Act heavily favors these agreements, and arbitration is incredibly advantageous for an employer.
Because it's private.
First, it keeps everything out of the public record. There are no explosive court filings for the press to read. Second, there's no jury of your peers, just a privately hired arbitrator.
Right.
And most crucially, it severely limits discovery.
Discovery being the legal process where you get to demand documents from the other side.
Exactly. In federal court, an employee suing for discrimination might be able to subpoena tens of thousands of internal company emails or, depose senior executives for days to prove a pattern of bias. In arbitration, the arbitrator might limit you to just a handful of depositions and a very narrow window of emails. It makes it exponentially harder for an employee to prove systemic, behind-the-scenes discrimination.
So for decades, if you signed that clause, you were basically trapped in that private forum.
Completely trapped.
And if you look at the employment contract you signed for your current job, you likely have one of these arbitration clauses buried on page 12.
Oh, almost guaranteed.
But Owens had a wild card. She utilized the EFAA, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021.
Yes.
It's a relatively new federal law, and it fundamentally alters the balance of power. The EFAA states that if a person alleges conduct constituting a sexual harassment dispute, any pre-dispute arbitration agreement becomes totally invalid.
Right. You get to bypass the contract and stay in a public federal court.
But this requires a very specific legal trigger, right? You have to plausibly allege sexual harassment.
You do.
And this is where I actually have to push back a little on the application of the law here.
Okay, let's hear it.
Owens' complaint is entirely about stolen revenue credits, being denied business leads, and hearing ageist comments about being old. Those actions absolutely qualify as gender and age discrimination.
Sure.
But does that actually count as sexual harassment? I mean, when we hear the term sexual harassment, we naturally think of inappropriate advances, lewd comments, or romantic coercion. A dispute over an accounting master code doesn't fit that mold at all.
Yeah. And that exact tension is the most intellectually fascinating part of the judge's ruling.
Okay.
The court had to explicitly draw the legal boundary between gender discrimination and sexual harassment.
Yeah.
Because Owens sued under the New York City Human Rights Law, or NYCHRL, the federal judge had to look at how the city defines those terms.
And the NYCHRL is unique because it protects against both discrimination and harassment. But the statute itself doesn't explicitly define what sexual harassment is, right?
Right. It just says it's unlawful to discriminate against someone in the terms, conditions, or privileges of employment based on gender.
So what did the judge do?
Well, the judge turned to the New York City Commission on Human Rights for guidance. The commission operates on the principle that the NYCHRL is intended to be highly protective.
Okay.
It acts as a one-way ratchet, meaning it serves as a baseline floor for civil rights, not a ceiling.
Gotcha.
The judge concluded that under this broad city law, sexual harassment is essentially a subcategory of gender discrimination. Crucially, the legal definition of sexual harassment is simply unwelcome verbal or physical behavior based on a person's gender.
Oh. Meaning the behavior does not have to be romantic, lewd, or sexual in nature to qualify.
Precisely. If a supervisor physically shoves you or screams at you, and they are doing it specifically because of your gender, that constitutes sexual harassment under the NYCHRL.
Even if there is absolutely zero sexual undertone to the action itself.
Exactly.
Okay, so applying that definition to Owens' case, the judge took all the alleged bad behavior from her colleagues and sorted it into two distinct buckets, right? Bucket number one is behavior that is discriminatory, but not harassment. This is where Jim Russell and John Garvey landed.
Correct. The allegations that Russell and Garvey worked behind Owens's back to deny her business leads, intercepted her contracts, and made broad statements that women make terrible consulting partners. Those were deemed plausible claims of discrimination.
But not harassment.
Right. The judge ruled they did not cross the line into sexual harassment. And the reasoning is rooted in the nature of the conduct. Intercepting a contract or reassigning a lead is structural sabotage happening behind the scenes.
Right. It's sneaky.
It isn't direct, unwelcome, verbal, or physical behavior directed at her face.
But, if stealing someone's hard-earned money and career opportunities behind their back isn't sexual harassment under the law, what actually is?
Well, that brings us to bucket number 2.
The allegations against a partner named Vishal Ralawal.
Yes.
Owens agreed to co-deliver a project with him in July 2023, and she alleges his behavior was outright abusive.
Completely. The complaint states that Rawl repeatedly yelled at Owens in front of subordinate directors. He allegedly pulled her into conference rooms to threaten and berate her.
Wow.
He explicitly told her not to speak on conference calls, commanding that he would do all the talking.
Yeah.
He even told male directors to exclude her from meetings entirely and to ignore her directions.
And the context is really critical here. Owens noted in her complaint that she never saw Rawl treat any of their male coworkers this way.
Which is key.
Other female partners had allegedly also complained about his disrespectful and derogatory conduct, and Owens went so far as to file a formal ethics complaint about him.
Right. And because of the direct face-to-face nature of this abuse, like the physical intimidation in conference rooms, the verbal yelling in front of others, and the plausible allegation that he only treated women this way, the court ruled this fell squarely into the definition of unwelcome verbal behavior based on gender.
Wow.
Therefore, Owens successfully alleged sexual harassment under the NYCHRL.
So it's like, if a coworker quietly sneaks into the accounting system and steals your revenue credits because of your gender, that is discrimination.
Right.
But if they aggressively yell at you in a meeting or physically trap you in a conference room to berate you because of your gender, it crosses the line into harassment. That visibility, that direct interpersonal confrontation is the dividing line.
That is the exact mechanism the law requires. And because she cleared that specific hurdle with the allegations against Rawal, she triggered the protection of the federal EFAA.
That's amazing.
The judge ruled that the forced arbitration clause was completely invalidated for her discrimination lawsuit.
Which is a monumental win for Owens. She gets to keep her civil rights claims in a public federal court where she has full discovery rights.
Yes, but modern corporate litigation is incredibly complex, and PwC executed a massive countermove.
Of course they did.
While Owens was fighting the civil rights battle in federal court, PwC initiated a completely separate arbitration against her through the AAA, the American Arbitration Association.
Wait, really? Yes, and in this private AAA arbitration, PwC isn't addressing the discrimination or harassment at all.
Right. They filed claims asserting that Owens breached the non-compete and client solicitation provisions of her partnership agreement. They are entirely contract-based claims regarding her post-employment behavior.
So Owens goes back to the federal judge and says, hold on. The EFAA just invalidated my arbitration agreement because I alleged sexual harassment.
Right.
All of this stems from the exact same messy divorce from the firm.
Right.
You need to pause this AAA arbitration too because the contract clause is void.
But the judge says no.
Why?
The reasoning comes down to a very strict textual interpretation of a single word in the EFAA statute, and that word is case.
Okay.
The EFAA explicitly states that an arbitration agreement is invalid with respect to a case which relates to a sexual harassment dispute.
So the court draws a hard line between a case and a claim. The judge points out that when Congress writes laws, they know exactly what they were doing. They use the word claim when they want to be narrow, referring to a specific cause of action. But they use the word case to mean the entirety of a specific lawsuit filed in court.
Yes. So Owens' federal lawsuit is one case. It contains her sexual harassment and discrimination claims.
Yeah.
And the EFAA protects that entire case from arbitration.
Right.
However, PwC's contract claims were filed in a completely separate arbitration proceeding. They were not brought as counterclaims within Owens' federal lawsuit.
Oh, I see.
Because they are a separate proceeding, they are legally considered outside the bounds of her protected case. The EFAA shields her federal lawsuit, but it doesn't have the jurisdictional reach to, cross the aisle and shut down a separate arbitration proceeding that involves entirely different legal claims.
Man, the result is just this exhausting dual-track reality of modern litigation. Nina Owens gets to fight her age, race, and gender discrimination claims in a public courtroom, shining a massive light on these internal practices.
Which is huge.
But simultaneously, she has to spend the time, energy, and money defending against PwC's breach of contract claims behind the closed doors of a private arbitration.
It proves that even when a powerful new federal law like the EFAA successfully opens the courthouse doors, massive corporations still have sophisticated mechanisms to leverage private forums for other aspects of the employment relationship.
It is a war fought on multiple fronts.
It really is.
Which brings us back to you. Why does this highly specific, nuanced legal battle over accounting codes and definitions matter to your daily life?
Yeah, why should they care?
Because the line between discrimination and harassment isn't just legal semantics for lawyers to argue over in chambers. As this case proves, it is the exact, tangible boundary that determines your rights. It dictates whether your workplace grievances get aired in a public courtroom where you can subpoena documents and set precedent, or if they are locked away in the shadows of private arbitration with limited discovery. Knowing how courts define unwelcome face-to-face behavior versus quiet behind-the-scenes sabotage could literally change the trajectory of your own career dispute.
Knowledge of these boundaries really is your best defense. The legal definitions applied to your daily reality at work dictate the venues where you can actually seek justice.
Yeah. And I want to leave you with a final thought to mull over. According to the complaint, PwC has a standard policy of mandatory retirement for partners at age 60.
Which is interesting.
Think about that for a second. If you are classified as an employee, federal law strictly prohibits mandatory retirement ages. The Age Discrimination in Employment Act makes that highly illegal.
Right.
But by utilizing the prestigious title of partner, how do massive corporate structures potentially bypass the standard age discrimination and employee protections that everyday workers rely on?
That's the real question.
Is the title of partner actually a reward for a lifetime of hard work, or is it a legal shield designed to protect the company? When you peel back the prestigious labels, the mechanics of corporate power look very different. Thank you for tuning in to this exploration of the sources. Take care out there.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.